So when I was discussing with the organizers, when I was deliberating with the organizers on the topics which I should be discussing in today's talk, I was told that I will have to discuss with an examination point of view, because most of the participants in today's webinar are students who have jurisprudence as a subject in the examination that is soon to follow. So I will have to discuss with an exam point of view. But at the same time, what I was told and what I as a student also am aware, that not many of us are keenly interested in this subject of jurisprudence. So I was also entrusted with this responsibility to somehow develop an interest in jurisprudence as a subject. So therefore, obviously, we will discuss with an exam point of view, but at the same time, I will try to develop an interest in the subject of jurisprudence. And if one is to try to develop an interest in jurisprudence, I think it is very much imperative to discuss the various theories in jurisprudence, the positive law, natural law, the sociological school, discuss all these schools in jurisprudence, and then try to, show the relevance of jurisprudence even today in the contemporary the legal setup that we have. And that is how probably an interest in the subject may be developed. So what I have decided for today is that we will take up the positive law theory in a sort of a comparative analysis with the natural law theory, and we will discuss the relevance of positive law and natural law, and in general the various legal theories in today's context. So that is what I have planned for today. We will do a brief run through of positivism and of the natural law theory. We will look at who the great scholars of these schools were and what they have laid down, what jurisprudence they have laid down. And obviously, we will be doing this with an examination point of view, keeping in mind what the Mumbai University will expect from you. I am told that it is going to be an MCQ examination with some part being on the theory, but I am not quite sure about that. But nevertheless, having cleared jurisprudence only 3 or 4 years back, I know what the Mumbai University generally expects. So we will also study this positive law theory and the natural law theory from an examination point of view, highlighting the important elements which are necessary for clearing the examinations. And then we will try to delve a little deeper into the study of positive law and natural law, and try to show the relevance of this in our today's Indian constitutional order, so to say. So as far as positive law is concerned, when we begin a discussion on positivism, we will first have to discuss about Austin. Obviously, prior to Austin came Jeremy Bentham, who has talked about utilitarianism. But the foremost scholar of positivism is Austin, and the general positivism which we understand, or rather the positivism which is relevant for Mumbai University examinations at least, is Austinian positivism. So we will first have to come to this fellow Austin and see what he had to offer, what his study of jurisprudence was, and what his school of thought was. Obviously, jurisprudence revolves around law. All the jurists will try to answer these questions as to what is law, what is the function of law, what are the sources of law, what is not law. All these questions all the jurists have deliberated upon. Austin obviously does the same thing. The first distinction which Austin makes is between law properly so called and law improperly so called. You can make notes also, you can make simple notes of this, because all this is going to be very relevant. He makes a distinction between law properly so called and law improperly so called. In law improperly so called, again there is a classification. He classifies it into laws of analogy and laws of metaphor, which are not very relevant for our purpose, at least in today's discussion. Now, as far as laws properly so called are concerned, he again makes a twofold distinction. He talks about laws of humans and laws of gods. It is this law of humans which is relevant again for today's discussion on Austinian positivism. This law of humans again is classified into two parts. This is then in this there is positive law, which is a positive law which forms the core of Austin's philosophy, and positive morality. He calls international law to be positive morality because it is not the law stricto sensu, according to Austin's understanding of law. Now, in positive law, what according to him is law? After discussing this classification of Austin of the forms of law, we then come to the definition of positive law as has been provided by this great scholar. Now, for him, law is a command. It is a command of the sovereign. This command of the sovereign is backed by sanctions in case of non-compliance. As simple and plain as that. Then these commands are again general commands and special or particular commands. So his theory mainly focuses on the general commands. So if you have to break down this definition, you will come to know that for Austin, law consists of a set of commands. This set of commands, these are commands which come from whom? These commands come from a sovereign. What is a sovereign according to sovereign? According to Austin's understanding, what is a sovereign? The sovereign is indivisible, it is unlimited, and it is absolute. So an absolute sovereign, in exercise of his sovereign powers, is entitled to issue you commands. Those commands which are issued by the sovereign become law, and they become law why? Because they are backed by sanctions. What is a sanction? Sanction basically is a punishment. So if you do not comply with this command of a sovereign, then sanctions may be imposed upon you. So according to Austin, it is only this command of a sovereign backed by sanctions in case of non-compliance that is law. And that is all about sovereign's understanding of positivism. Obviously, he has delved into it in much great detail. It is a big treatise and there are several criticisms also. We will quickly go through the exceptions and the criticisms also which have been leveled on this Austinian positivism. Now, according to him, there are three exceptions. There are three laws which are not commands, but then he yet calls them law. The first are declaratory laws. What is declaratory law? Laws which are already passed. Then there are laws of repeal. Laws of repeal, again, since laws of repeal are not commands, so to say, he does not regard laws of repeal as laws strictly. And then there are laws of imperfect obligation. These are the three exceptions. We will not go into much detail, but for the purpose of the exams, this much knowledge is sufficient. Then we come to the criticisms. The foremost criticism of Austin's theory is that he is giving too much importance to the sovereign. But then he forgets, unfortunately, that it is not the sovereign who is the only source of law. Prior to the sovereign as well, there are commands which have been given. Even during the existence of a particular sovereign, there are some other forms, other sources of law, such as custom, which he has totally ignored. And there may be forms of law which are not commands, but nevertheless pose a great influence on the society at large, and the society follows such commands due to some kind of a societal pressure. So he is completely ignoring all these other sources of law, giving too much importance on the sovereign as a source of law, and then again he is giving too much importance on law as a command. It is not that law is always a command. That is one typical criticism. Then again he ignores judge-made law. This is a criticism which has been offered particularly by the realist school. We will briefly discuss what the realist school is. The realist school says that judge-made law has been ignored by Austinian positivism, because according to the realist school, it is the law that is decided in the courts that is the real law. But Austin does not regard that law as law at all. Obviously, he regards international law as positive morality, does not give any regard whatsoever to international law because it is not a command of a sovereign, obviously. But then again, international law is also backed by certain kinds of international sanctions which are concerned with the diplomacy between nations, which the common man may perhaps not understand. But then international law also has certain sanctions, which in fact give them a force of some kind of a command on the as far as the diplomatic relations are concerned. Then again, obviously, there is overemphasis on sanctions. There is overemphasis on the punishment part, because it is not that, according to him, if there is no punishment, if there is no fear of sanctions, then it cannot be called law at all. That is his understanding. He is a very, he, we may say that Austin has understood law in a very strict sense, and he is not ready to delve to other aspects of law, to consider customs, to consider the judgment law, to consider precedents, to consider the conventions. He is not delving into all that. The clear-cut positivist, the typical positivist that we will see, if we are to see all the various positivism jurists, is Austin. Therefore, he is regarded as the foremost in this school of positivism. Then we have certain other positivists also who have not been identified as positivists as far as the Mumbai University syllabus is concerned. Now we have Jeremy Bentham. What did Jeremy Bentham do? Jeremy Bentham was a utilitarianism. He was a utilitarian, and his philosophy of utilitarianism, which he propounded, talked about the greatest happiness of the greatest number. So the best measure of law is the greatest happiness of the greatest number. That is his foremost philosophy. But again, this philosophy is also in line with the positivism of Austin, because it is from Jeremy Bentham's utilitarianism that Austin has taken inspiration and founded his idea of positivism. Jeremy Bentham also in a way is a positivist, because he does not have much regard to the natural law philosophy or the natural law school. He is also one very important positivist. Then we have Kelsen. Kelsen, again, we learn about Kelsen as a person who has propounded the pure theory of the pure law theory. He talks about the grand norm. He divides law into facts and norms. Facts are facts which are existent, and norms are the ought element. That ought element is what ought to be. And law, basically, according to him, is a set of norms. For example, it is not right to commit murder. This is a norm. This norm has a force of law because of some higher norm. That higher norm again has a force of law because of a further higher norm. And the highest norm, according to Kelsen, is the grand norm. And that grand norm is the supreme norm from which all the norms flow. And that is what Kelsen has to offer. We understand it as a pure theory of law, but again, Kelsen again is a positivist, so to say. This is all about positive law in brief. So what we understand from positive law is that the positivist will say that whatever the law is, we are required to follow the law as it is. He will not focus much on the normative aspects. He will not focus much on the justice element of law. He will not adhere to the principle that an unjust law is not a law at all. And that is what a natural law criticism of positivism is. That there is too much focus on what the law says, on what the law lays down, and other things are not being looked at. So positivism focuses on the principle in which we use in economics, other things being constant, while laying down its philosophy. So all positivists, in a way, are have just simply focused on what the law is and how the law is laid down. So we may say that positivism focuses on it is too much formalist. It focuses on the formal element of law, and therefore it is subjected to severe criticism from schools such as the natural law school, which focuses on more on the justice element, so to say. But again, the criticism of the natural law school that justice is compromised is, again, you may say that it is unfounded, because the law of a positivist, which has been laid down perhaps in a code, is based on principles of justice. It has been based on principles which are propounded by the naturalists. So it is not that a positive law is always going to be a law which disregards justice. And ultimately, in the modern world where we see codified laws, a positivist will obviously argue that it is the positive law which is functioning in the modern day world and it is the positive law which appears to be working well. Now we come to the natural law theory. Again, we will do a basic run through of who these jurists of the natural law are, what this natural law basically is, what is the basic premise of natural law, the basic principle which is laid down by natural law. The basic principle is this, that there are certain constant bodies of permanent truths. These permanent truths are immutable and eternal. You cannot touch these permanent truths. That is the basic philosophy of natural law, or rather most of the jurists of the natural law school. What this natural law focuses on is an a priori understanding. A priori understanding means some kind of a rational understanding or some kind of a reason which all human beings possess about what is right and what is wrong. So it is not affected by human beliefs as such. It is affected by reasons implicita. Obviously, this is going to be subject matter of serious criticism because value systems, standards of reason change from time, place, and circumstances, change from regions. So therefore, since the standards of reason change, this a priori understanding is also going to be changing, and therefore the notions of justice, the value systems are going to change, and therefore this natural law school ultimately, without a proper codification, is going to be meaningless. The natural law school, we will be dividing, we can see that it has been divided into largely into four parts. The first is the ancient period, the philosophers of like Socrates, Plato, and Aristotle. Then there is a medieval period. In this medieval period, there were thinkers such as Saint Thomas Aquinas, Saint Augustine. Then there is this Renaissance period, wherein we have seen theories such as the social contract theory, which has been propounded by Hobbes. We have Hobbes, Locke, Rousseau. All of these are from the Renaissance period. And then we have the modern period also, where we have Dworkin and certain other philosophers. Let us look at the ancient period first. The ancient period goes back 2500 years ago, where we had Socrates, Plato, and Aristotle. This was a kind of a Guru Shishya Parampara of these three. Socrates is the first one, who focuses on the virtue in every man, and this virtue, according to him, can test the positive law. So, whether a positive law is right or wrong, you will be able to answer this question based on the virtue in every man. After him comes Plato. He talks about idealism. He has authored the books Republic, Apology, Symposium. All this may be relevant for the purpose of the MCQs which you may have to attempt in your examination. Then we have thinkers such as Zeno, we have Cicero. Cicero said that law is the highest reason implanted in nature. This is the ancient period. All of them again, their theories which they have propounded were subsequently modified, offered in a better perspective with certain additions and modifications. We then came to the medieval period, which was in the 10th and from the 10th to the 12th century, where we had Saint Augustine and Saint Thomas Aquinas. What Saint Thomas Aquinas did was that he divided law into four stages rather. The first is the laws of God, the second is natural law, the third is divine law, and the fourth are the human laws, or the what we call as the positive laws. Laws of God, according to him, are laws of God, given by God. We are not concerned with them. The natural law, according to Aquinas, is the law which is revealed by the reason. So this natural law is going to reveal itself. So again, a typical natural law philosopher who says that it is going to reveal itself by reason, you are going to know it. By its very nature, you are going to know it, and you are going to be able to test positive law on the basis of this reason which you possess. That, according to him, is the natural law, and it, according to him, is the test for the validity of positive law. Then we have the divine law. What is the divine law? The divine law is scriptural law. What is scriptural law? It comes from the church authorities. It has been propounded by the church authorities. Then we have the human laws, which are the positive laws. These human laws or positive laws must conform to reason and must therefore conform to natural law. So the test of positive law is whether it conforms to the natural law. So basically its test is that whether it is conforming to the standards of reason. We then come to the Renaissance period from the 14th to the 17th century, wherein there were thinkers such as Hobbes, Locke and Rousseau. Now in our Mumbai University syllabus, we learn social contract theory differently. We learn historical jurisprudence differently. But if you are to club all this into one umbrella, then all these schools, by and large, all these thinkers, you will find that there is a lot of overlapping. And you may call all of them to be falling within the umbrella of the natural law theory, the natural law umbrella, so to say. Now, what did Hobbes say? He propounded his social contract theory. He said that the society in the foremost primeval period, it was a nasty society where all of the people had the fear of death. And basically, it was a sort of a jungle Raj, according to Hobbes. And therefore, he said that because of this fear, living in the constant fear, and because of this jungle Raj, there was a transfer of entire power to the state. This institution of the state was born, and from this institution of state, which was given the entire power, all the sanctions and everything was derived, and the law, so to say, was derived. So Hobbes, the foremost philosopher of the social contract theory, believed that the entire power is to be transferred to the state, and the state is the supreme sovereign, indivisible, immutable, and absolute. He has written a book by the name Leviathan. This is again a question which is often asked. What is a Leviathan? Leviathan, according to him, the Leviathan, according to the ancient mythology, he is a sea monster. This is a sea monster who is devouring everybody. And this sea monster is to be somehow curbed. And therefore, this social contract. That is what he interestingly propounds. After Hobbes, we have Locke. Now, John Locke, unlike Hobbes, he focuses very much on individualism and civil liberties, individual liberties. Hobbes is absolutely not concerned with your individual liberties, with your civil liberties, individualism, the right to life, right to property. He is not concerned with all this. He simply says that there is a nasty society. Because there is a nasty society, there is a fear of death, there is barbarism, and therefore entire power transferred to the state. The state is a sovereign, it will now take care of you, you lose your individuality to the state. Unlike Hobbes, Locke in fact says that there should be individual liberty, there should be the right to property, and not all rights, according to John Locke, are given to the state. Some rights the individual will preserve with himself. And he again does not believe in the principle that the government is unlimited, indivisible, immutable. He does not agree with all this. Then we come to Rousseau. What does Rousseau say? He talks about the theory of general will. Again, a very typical question which is asked in examinations as to who has propounded the theory of general will. It is Rousseau who propounds this theory of general will, where he says that there will be preserving of the rights and freedoms, but these rights of the are surrendered not to the individual but to the community as a whole. So it is not that the state as a political entity comprises of an individual or two individuals or few individuals to whom you are surrendering all your rights, and then they being absolute, they can do what they please. That is not what Rousseau's understanding is. Rousseau says that your rights, when you create a state, are surrendered to the general rights, general will, or to the community as a whole. So your individuality is not surrendered to the state at large. Your individuality is surrendered to the community as a whole. So therefore, again, unlike Hobbes, he also does not believe in an unlimited and absolute sovereign to whom all your rights you have surrendered, without there being anything with you at all. That is not what he believes. Then under the modern jurisprudence, modern school, modern times, you have people like Hume who have rejected this a priori notion, who have said that it is not that the value systems remain constant, it is not that the reason remains constant, and therefore natural law also changes. And natural law also will have to answer several questions which may be posed to it. Then we have people like Dworkin and several others. In the medieval period also, I talked about Saint Augustine, who said that lex injusta are non-est lex, which means that unjust law is no law at all. Saint Thomas Aquinas did not believe in this. He simply said that there will be positive law which will have its purpose, and this positive law will have to derive its authority from the natural law. So obviously it is not going to be that it is going to be an unjust law and therefore no law at all, since it will derive its authority from some kind of a reason which man possesses on his own. That is what Aquinas propounded. But in the modern times, we see in our Indian constitutional jurisprudence that we have catered to this positivism of Austin. At the same time, we have also inculcated the natural law theory, which has been propounded by people like Augustine and Aquinas, and we have developed our own constitutional jurisprudence. And that is so for all the countries all throughout the world. So we will now come to the relevance of this study of jurisprudence in modern times. We will have to answer certain questions. What is the relevance of this study of jurisprudence for us? Which school of jurisprudence do we follow? Is the understanding of these various characteristics of these schools of jurisprudence really even necessary today? It is this interplay, according to me, between these various schools that has developed the system of law which is existent today. So, in order to understand the beauty of jurisprudence, in order to understand how positive law, which has been laid down by Austin, merged with some kind of a natural law understanding of Aquinas, who says that unjust law is no law at all, or that of or rather Augustine, who says that there is unjust law is no law at all, or of an Aquinas who suggests that this positive law will have to derive its sanction from reason, and which reason comes from natural law, or of some kind of a Kelsen who says that there is some grand norm from which all laws in fact flow. We will understand the beauty of jurisprudence in this manner. In our constitution, you will notice that this term law has been defined. Where is this term law defined in our constitution? It has been defined in Article 13 of the constitution. Positivists have made attempts to define law. Naturalists have made attempt to define law. The historical school of jurisprudence has made an attempt to define law. All defining law in different terms, in different understandings. Unlike all of them, Constitution defines the law in a very different manner. In Article 13 of our Constitution, law has been defined as including several different things. It includes the resolutions, notifications, rules, circulars. It obviously includes the legislations, though it has not been mentioned therein. It includes customs, usages. All this is a part of law as it is understood by our Indian constitution. A positivist like Austin will say that, sorry, your constitution is regarding custom as a law, and that we do not agree with. Custom cannot be a law. A naturalist will say that we understand what your definition of law is, but your definition of law focuses too much on codified law, focuses too much on the text of the law without focusing much on the justice element. We have in our constitutional jurisprudence answers for both the positivist and to the naturalist. And our constitutional jurisprudence, you will in fact notice, has derived from all these schools and come to the constitution that we have today. Let us take the case of someone like an Augustine who says that unjust law is no law at all. In our constitutional setup, take the case of a law which someone may regard as an unjust law. Take the case of some kind of a GR, because government resolutions are also law as per our constitution. There is some government resolution. Take the case of a lockdown, for example. Lockdown is imposed by subordinate legislation. It is imposed by delegated legislation. Power of the state to impose a lockdown is derived from the plenary legislation, such as the Disaster Management Act or the Epidemic Diseases Act. Now a lockdown is imposed. It has a force of law, because under our setup, under our system of codified laws, this particular law, the text of the order of a lockdown, has the force of law, and you are required to follow this law. You may regard this as an unjust law. You may feel that why in Maharashtra there should be a blanket lockdown all over throughout the state of Maharashtra. Cases are not high in the rural areas. Why in the rural areas also people are made to sit at home? Businesses are being, small businesses, the unorganized sector is being hit at a large scale. So this lockdown is unjust. We don't agree with this lockdown. What do we do then? Augustine says that unjust law is no law at all. And then the natural law thinkers tell us that ultimately, to ascertain the validity of a law, you will have to go back to reason. That reason is derived from yourself. You can ask the question to yourself as to whether a law is valid or not, and you will get an answer. That is what that is what the natural law thinkers propound. But then again, there is a clarion call of natural law thinkers such as Augustine, who say that unjust law is no law at all. And the beauty of our constitutional jurisprudence, our existing legal structure is, we don't say no to Augustine, we don't say no to Austin either. We have means, we have ways and means. If you think that a lockdown which has been imposed is unjust, our constitutional jurisprudence has given us ample remedies. Even if a law is unjust, and even if you are thinking that it is no law at all, it will have to be so declared. It will have to be declared that this law is an unjust law, and you will have to do away with this law. How do you do away with this law? Article 13 itself gives you an answer. Article 13 says that if there is any law which abridges or abrogates the fundamental rights. Now when we talk about fundamental rights, and when Article 13 propounds in this manner, that if there is a law which takes away the fundamental rights, then it is void to that extent. And who will declare it to be void? It is the courts. It is the High Courts under 226 and the Supreme Court under 32, which will declare that yes, this law violates the fundamental rights, and therefore this law is void to that extent, and it will therefore have to be struck down. Here again we see that a natural law thinker who propounds reason is satisfied. Someone like a John Locke, who propounds the social contract theory and gives the powers to the state, but then he says that my liberties I want to maintain with myself. It is not an unlimited state. The state has to be bound by some kind of a rationality. That rationality we find in natural law. And because of this part 3 of our constitution, the natural law is also a part of our constitutional setup, where it will have to, any law that is made will have to be compliant with this fundamental rights chapter. A person who propounds a pure law theory, a person like Kelsen, would say that yes, here is a grand norm. The constitution is a grand norm to which all the laws, other laws, will have to, they will have to satisfy the test of the constitution, so to say. They cannot travel beyond the constitution. They cannot travel beyond the fundamental rights chapter. So a positivist will say that yes, there is a command which everyone will have to follow irrespective. This command has been issued by a sovereign, but that sovereign again is not absolute. So a naturalist will also be satisfied. A naturalist such as Locke will also be satisfied. An absolute naturalist such as Saint Augustine will also be satisfied, because he will see that yes, if it is an unjust law, there is a remedy. That remedy also, now I mentioned about judicial review as a remedy to do away with unjust laws, but it is not that judicial review is the only way in which unjust laws can be done away with. Judicial review will focus only on a limited sphere, it will only discuss whether fundamental rights are violated or not. You have the force of public opinion, you have the strength of agitation, which obviously comes with a caveat that that agitation has to be a peaceful agitation, which will also ensure that a particular sovereign will not act in an unjust manner and trample upon your rights by creating an unjust law. So therefore, these theories, these schools of jurisprudence which we see are going to be of very much relevance in our existing constitutional setup as well. The theories such as the utilitarianism that has been propounded by Bentham, who says that the greatest happiness of the greatest number is to be of paramount importance, is also enshrined in the very principle of democracy, which forms part of a basic structure of the constitution. That the will of the people at large is going to manifest itself through the votes, and the popular government is going to be a sovereign. But again, this popular government is not an absolute sovereign. It cannot take away your individual rights and liberties, and it will have to act according to reason. So therefore, whenever we are encountered with any legislation, or whenever we are encountered with any action of a government or of a so-called sovereign, though there is no, in our constitution, it is not that the government or even the legislature is sovereign. So whenever we are encountered with any law as per our contemporary understanding of law, we will have to look at it from the lens of jurisprudence. We will have to look at it from the various angle of the various schools of jurisprudence. What kind of a law is it? Does it satisfy the test of reason? You can interestingly, you can look at various laws from the perspectives that have been offered by various jurists. Now, in several journals which focus on jurisprudence and constitutional law, you will come across several interesting research articles and research papers which focus upon particular laws from the lens of particular jurists. So you can perhaps find a Dworkinian analysis of a particular law, or you can analyze a particular law from the lens of the writing of some jurists such as Fuller or John Finnis or Mill or Bentham for that matter. And you can analyze laws in such a manner by reading the treatises of these great jurists, these scholars who have laid down their own schools of law. And then in that manner, you will understand as to how interesting this subject of jurisprudence is. Unfortunately, I must say that the manner in which the syllabus of jurisprudence has been framed in the Mumbai University particularly, and also in several other traditional universities, there is not much room for you to develop an interest in the subject of jurisprudence. You will only end up focusing on the examinations and understanding jurisprudence from an exam point of view. So you will only see the definitions that have been provided by these various scholars. You will rectify those definitions. You will go in the exam and write down those definitions in that manner. You will be asked some stupid questions like who is the author of which book, which is not even very relevant. So therefore, you may ask a question to yourself as to whether it is really necessary for me to study this subject of jurisprudence. Therefore, we now see several memes which mock this subject of jurisprudence, finding it very unnecessary in this contemporary legal syllabus. But it is not that the subject is bad, it is the manner in which this subject has been introduced to us in our syllabuses and the manner in which the examinations of these subjects such as jurisprudence are taken, that we find these subjects to be very uninteresting. But if we are to read all these theories that have been propounded by these several jurists and understand them in the context of the contemporary legal setup, of the contemporary jurisprudence, or if we are to undertake such exercises of picking up a particular law, of picking up a particular legislation, of picking up a particular government action, executive action, and analyzing it from the lens of these various schools of jurisprudence or from the lens of these particular jurists, we will then enjoy this great exercise, or we will enjoy this subject of jurisprudence. And that, according to me, is going to be a way out from this, and that is how we will be able to develop an interest in this subject of jurisprudence. So in the time that has been allotted to me today, I have ensured that I will delve briefly into what positive law is, what the foremost scholars of positive law have said, what natural law is, who are the famous natural law thinkers and scholars, and what they have propounded.
That you started practicing, and you've always shared with us that you had great interest in jurisprudence. So did it ever help you with any case?
In the stage in which I am right now in practice,
Yeah.
I am not going to be obviously in a position to deal with issues of great significance in constitutional law. So therefore, the study
Yes.
of jurisprudence is not going to be of much assistance in your landline practice. But obviously, given the interest that I have in this particular subject, I often indulge in academic writings, and in these academic writings, I often get great assistance from my uh, interest rather in jurisprudence more than my understanding of the subject of this. The interest in the subject is what helps me more. But I must say that in the future, obviously, this subject, particularly coupled with the understanding of our contemporary constitutional jurisprudence, will definitely be of great assistance. And I think it is the joy that you get from an academic indulgence with this subject that is of immense importance, more than the practical use of the subject in the course of law in the day-to-day practice. Because in the day-to-day practice, obviously, it is not going to be of much relevance. Even constitutional law in the day-to-day practice of a high court lawyer, of a young high court lawyer particularly, it is not going to be of that great a relevance. Which books we should refer for the examinations? Now, if he is a Mumbai University student, I will highly recommend Jhabwala, and I will tell him to not go beyond Jhabwala because it is absolutely not necessary to travel beyond Jhabwala. But for those who have a real interest in this subject, there is one very expensive book, Lloyd's Introduction to Jurisprudence. I think it is for about around 3,500 to 4,000 rupees. It is very expensive, but it exhaustively covers this subject. And what it does is
Can you please spell it, the book?
Lloyd's Introduction to Jurisprudence, LLOYDS, Lloyd's Introduction to Jurisprudence. It is a
Okay.
very expensive book, but then the best part of it is that it has extracts from the various treatises, or it has extracts from the best writings of all the jurists who have written great works in this subject of jurisprudence. So for developing an interest in the subject, or for higher studies in this subject, I would definitely recommend Lloyd's Introduction to Jurisprudence. But otherwise, from an exam point of view, I think Jhabwala is the best thing to use. I will not recommend usage of some other books. You may consider Salmond. Salmond on jurisprudence is also a useful book. But beyond Salmond, I don't think it is necessary for the Mumbai University students to travel any further if they are looking at it from an exam point of view.
That as a fresher, theories and the schools of jurisprudence become a bit confusing. So, do you have any tips for our participants? Because they have MCQs. So, any tips that you can share on how can one approach the different theories and schools of jurisprudence?
See, the best thing to do for understanding of constitutional law and jurisprudence particularly is to contemplate. And the contemplation is going to develop that interest, and contemplation is going to give you take you that extra mile as far as jurisprudence is concerned. You may read books, you may read for the exam, obviously, you can read Jhabwala. But for better understanding, you can, if you are really interested in the subject, you can buy good commentaries and read from those commentaries and contemplate. Because contemplation and thinking is going to be giving you very interesting perspectives. Those interesting perspectives will come to you yourself from contemplation. And particularly for these theoretical subjects, I think contemplating is very important. Ask certain questions to yourself, look at certain laws from certain perspectives, see how you can analyze a particular legislation from the perspectives that have been offered by certain jurists. Like, for example, if you are dealing with, you can pick up a legislation such as a surrogacy bill. Now, that surrogacy bill is not an act as yet. You can pick up the surrogacy bill, which prohibits commercial surrogacy, and it only talks about altruistic, or rather allows only altruistic surrogacy. You look at this from the perspectives of gender justice. What does gender justice say? what are the perspectives on gender justice that have been offered by the natural law thinkers such as perhaps such as Dworkin or Finnis? What do they say about gender justice? From their perspectives, how can we analyze bills such as the surrogacy bill? Or for that matter, there are several penal legislations such as the POXO Act, for example, or the recent amendments to the Indian Penal Code. How do we look at these from the perspectives of these jurists? Or you can take, for example, the death penalty. What do these jurists have to say about the death penalty? How do you connect the death penalty with a natural law theory, or a theory that has been propounded by somebody like a Hobbes, or for that matter, somebody like a Montesquieu? How do you understand death penalty by looking at their theories? You can experiment basically in this manner, and that is going to be helping you in developing an interest in the subject. Is there any situation where we can use the theories of jurists while claiming for compensation or remedy with the help of 32 or 226? Now, the constitutional jurisprudence clearly has laid down that under 32 and 226, under the writ jurisdiction, compensation can be sought in certain cases, particularly in cases in habeas corpus petitions where the arrest is illegal. So you can obviously use notions of justice which have been propounded by certain philosophers to say that where there is some kind of a wrong that has happened, there should be a remedy which should be available. So where there is a right, there is a remedy, and that remedy cannot be rendered useless simply sit by a declaratory relief. So therefore, there should be compensation. You can read it in this manner. It is not that for everything, every situation that you come across, there is a necessity to look at jurisprudence. Sometimes you can simply look at the settled position of law if it helps you and proceed therein. It is not that you need to look at every situation from a jurisprudential angle, so to say.
So, as you have told that to understand the subject, we should analyze the law with the lens of different jurists. So, can you just, with your experience, tell that any of the jurists whose ideas can be implied in today's date? And the second question is that in our the definition of law is defined in our constitution in article number 13. Does our constitution is inspired by any of the philosophers in making those definitions? Yeah.
No, see, ultimately, philosophers have laid down their own treatises. They have given their answers to several of the questions which all jurists and all lawyers, especially
Yes.
constitutional lawyers, encounter every day when they deal with certain questions about law and justice. When the constitution makers made this constitution, they were furnished with several world constitutions, and on a study of those several world constitutions, they have made this document. Each of the person in the Constituent Assembly came with his own philosophy, had his own understandings of reason and right and wrong, and accordingly, after deliberation, this positivist core has been laid down. It is a codified law, and this codified setup has been laid down, which you, which is from several jurists. It is not that those inspirations may be laid down in the constitution in express terms, but like for example, you have a Montesquieu who propounds a theory of separation of powers, who says that if there is power which is zeroed in one or other focused or compacted in one authority, it is going to be abused. So that is a separation of power thesis of Montes, which we find in our constitutional setup as well, where there is a separation of power. So in that sense, you will find that several constitutional provisions or this entire constitutional setup is influenced in part by the opinions of several jurists or the treatises of several jurists, though they may not refer as such to such treatises. But those influences you will find everywhere. And it is not also that when the constitution framers framed a particular provision, they had in mind opinion of a particular jurist. But ultimately, it is reason which prevails, and it is reason which dictates how positive law is going to be framed, and it is in that manner that our constitutional provisions have been enacted, and the constitutional jurisprudence as interpreted by the courts has developed. Ultimately, what natural law says is that it is reason which prevails, and accordingly reason prevails in every person who is interested with the task of laying down a law, and also the task of interpreting a law.
I'm trying to pursue for the net exam, which is going to be in the next month or so. So could you guide me regarding, because jurisprudence is going to be an important topic in net preparation also. So what more needs to be studied pertaining to jurisprudence?
If you are to seek to qualify the net exam, for the net exam of law, I also attempted the net exam on the last occasion. You cannot really expect a particular question, because the syllabus itself is so vast that
Okay.
no matter how much you read, it is not going to be, it is really not going to be enough. But then,
Okay.
in that exam, I will recommend a holistic reading of Salmon. Salmon on jurisprudence covers almost everything. Holistic reading of Salmon would be sufficient as far as the jurisprudence part is concerned.
Mr. Jethmalani used to quote from jurisprudence, like from the theories and all that. But he was a famous lawyer. Like, do judges give an ear to lesser known lawyer when he starts quoting from these judges and all these maybe international judgments and all that?
All judges are going to give a hearing if whatever is said is relevant. If it is not relevant, you will not get a hearing. That is,
Okay,
it's
okay.
as simple as that. The objective of this talk, well, obviously, it was to enlighten the students from an examination point of view. But enlightening from an examination point of view, as far as the Mumbai University exams is concerned, is not a task which is very difficult. But what is really difficult is to engage with students in order to develop an interest in the subject of jurisprudence. And that, I think, is the foremost objective of this talk today, that we have to try to develop an interest in this subject. And I think that an interest in this subject can only be developed if students develop a vision, or attempt at least to develop a vision to look at every scenario, every legislation, every law, or everything that is happening in society around you from this perspective of reason, or from this the perspectives of the various jurists. And for that matter, even if one is to look at a particular law from one's own perspective, one would notice that his or her perspective again is, there is some jurist who has laid down a similar perspective, and such perspective building is very essential. And jurisprudence will help in perspective building when you read the opinions of the several jurists on what law is, and what law ought to be, and what law is not. You will be able to develop great perspectives, and those great perspectives that you develop are going to be very helpful to you. And for all those who wish to develop a great career in litigation in the apex court, the Supreme Court, and all those who want to be great constitutional lawyers, for all of them, it is very essential that you have a great command on jurisprudence. That is going to be of the essence. And even in the academia, we nowadays see that everybody is interested in going into, or doing the fields in corporate law. They are interested in placements in big corporate firms. But for those who wish to go into academia as well, I would like to say that a firm footing in constitutional law and jurisprudence is going to be of great help, because now in the recent times we see a dearth of good constitutional experts, or constitutional scholars or scholars in jurisprudence. So that is something that everybody can keep in mind, and indulge in perspective building. Thanks a lot.